Welcome, everyone, to this Lauterpacht Centre Friday lunchtime lecture. On behalf of the Centre directors and with special thanks to Cambridge University Press, I'm going to be the chair for this lecture. My name is Marcus Gehring, and it's my distinct pleasure to welcome Professor Natalie Klein, who is a professor at the University of New South Wales in Sydney, in the Faculty of Law and Justice, and the Associate Dean for Academic Affairs. She is a world-class expert on the law of the sea and has written many important books, including on dispute settlement under UNCLOS. She is also nominated as an arbitrator under that convention. And she's here today to present her latest research, which resulted in a forthcoming Cambridge University Press book on submarines in international law. And one of her co-authors, together with Kate Purcell, Jack McNally, is in the audience. Welcome, Jack, as well. She was a visiting fellow here at the Lauterpacht Centre and is a fellow of the Australian Academy of Law and the Australian Academy of Social Sciences. We are absolutely honored to have you here. And as one degree of separation, we both have a JSD, and we don't need to explain to each other what that stands for. So welcome, Natalie.
Thank you. Thanks, Marcus, for the warm welcome, and thank you everyone for coming along today. It's really a pleasure to have an opportunity to talk about forthcoming book, and particularly because Jack McNally is here, one of the co-authors as well. So the book is not yet in the bookstores, but I'm sure will be there quite soon. The purpose of the book was really on the one hand, why are you writing a book about an object in the law of the sea? But it's the very fact that submarines have become increasingly important strategically and in a variety of uses, and the awareness that the way international law deals with this is very patchy and needs further consideration. So that was sort of part of the motivation for the book. But what I wanted to talk about today is not just submarines themselves, but I guess a focus on the newest form of submarines, which is the underwater autonomous vehicles as well. So the idea is just to give you a sense of what it is we're talking about and then focus on a couple of the legal issues arising. I'll probably go over it all relatively briefly and hopefully allow some time for Q&A, which we can then, it's very hard to avoid all the puns. We can dive more deeply into so just bear with me with those ones, please. All right, so in terms of what we're talking about, submarines old and new, the submarines are really a thing of the 20th century, particularly the very first submarine that's apparently a picture of what it was supposed to look like. The Humley, which was used in 1864 in the US Civil War and was used the first time a submarine managed to attack a warship and cause it to sink, the Housatonic. Through to much more modern versions of the submarine, known by the much less exciting name as an XLUUV, an extra-large underwater uncrewed vehicle. When we're talking about submarines, of course, the reality is, and as you'll be aware of them, that they are predominantly warships at the end of the day. So when you're talking about how are they regulated, your first thought correctly is, well, surely they're warships. We knew about them all as U-boats during World War I and World War II. And now we talk about nuclear submarines that are being developed for Australia, particularly under the AUKUS agreement. And then in November, there was also an announcement that nuclear submarines are going to be built in US shipyards are for South Korea as well. So the number of non-nuclear weapon states will be increasing with the number of nuclear submarines. But it's also important to bear in mind that submarines are used by private actors as well. And certainly a couple of years ago, it would have been hard to miss the stories about the Titan submersible that went down to explore the Titanic shipwreck, only to implode and raise questions for lawyers in terms of, well, what are the laws that regulate the use of those submersibles? And of course, private usage, not just by high net worth individuals, but also by criminals looking to transport predominantly drugs, but obviously also weapons, money, and other illicit goods around. So when we were talking about submarines, of course, we had to think about, well, what is it that we're actually talking about? The terminology can vary, whether it's submarines, whether it's submersibles, and of course, within different navies, they're often referred to as boats. So there is a very basic definition that came out that we use from 1909 in terms of all vessels capable of navigating totally submerged. But I kind of liked not only that we had this definition, but the title of the article that it came from was Underwater Torpedo Boats, because that did capture one of the early issues around submarines, which is, are we regulating these things as ships or are we regulating weapons? And when you think about the modern forms of them, we're still having that debate, because it's a question of, are we dealing with autonomous maritime systems? Are we dealing with autonomous maritime ships? What kind of things are we dealing with? And that affects the regulation. And equally for submarines, we had to think about the idea of the semi-submersible, which are used for criminal purposes, leisure purposes within the navies, you see there, and give some thought to whether that changes things. Though, well, spoiler alert, the answer is mostly no in terms of semi-submersibles. But how we define these things does matter a lot once we start looking at the newest forms. So when we're thinking about underwater autonomous vehicles, what you can see here, on the top left is a glider, the type of glider that the US had launched in the South China Sea, and that China retrieved from the water and then held for a little while before it gave it back. And I included the picture below of another glider just so you can get a sense of the size of these sorts of things. So on the bottom left is a picture of a Chinese glider that some Indonesian fishermen found and turned over to Indonesian authorities. But even smaller than the gliders, you can see the top right. It is known as a float, which is being used for scientific research. And then we have also, of course, the robot sharks, so the spy shark that has been developed by China. So back in the day, Russia trained actual beluga whales to conduct spy activities, but now they don't have to train the animals, they can just use the robots instead. But all of this raises questions about terminology and legal regulation. So the terminology is very mixed in this area once we're dealing with autonomous vehicles. There are a lot of different acronyms that are used. Probably, to my mind, the most helpful is the underwater autonomous vehicles, but the problem with UAV is that it's also used to refer to unmanned aerial vehicles too, so that prompts some confusion. You see ROVs being used when you're talking about the really commercial ones that are used for mining activities and submarine cables and so forth. So we mostly call them underwater maritime autonomous vehicles in the book. But the terminology matters because one of the big debates we've been having around autonomous vehicles generally in the maritime industry is whether they count as ships or vessels. You kind of think, why do we even have to think about this? We're sort of going back to, we've had the law of the sea for centuries now, and we've never really had to think about, well, what is a ship? And certainly UNCLOS doesn't define it. So some national governments are starting to think about it. But when you see the gliders, you see the spy sharks, you go, well, are they actually ships? If they're not ships, then how do we start thinking about them? some international treaties do define what counts as a ship. And for our purposes, there's only a couple of the treaties that refer to submersibles. So we know for sure that our underwater maritime autonomous vehicles are included. One of the difficulties is the coal regs, which is the important one for navigational safety, only talks about vehicles that are capable of being used as a means of transportation. But in the spy shark, something that's capable of transporting something is a glider transporting something. I guess if it has recording equipment on it, then maybe it is covered by that definition. We have a further question when we're talking autonomous vehicles, and particularly because so often they are owned by the military, as to whether they are warships or not. And we have an initial issue again, are they actually ships? Because the definition of warships expects that they are ships. Then they have to be also commanded by an officer and also manned by a crew. So how do we meet those criteria when we're dealing with something that is autonomous? So some countries have started changing the definition that they use for warships. So far, the United States and France are two countries where we found that they've altered their definition to allow for the possibility of autonomous or remote control. You might think, well, why does all of this matter? And it does matter because once you're talking about the rules, some of the rules are specific to ships. Some of the rules are specific to warships. So these are questions we do actually have to answer when we're dealing with the newest technology. But to turn to a couple of the key legal issues, and first of all, to passage in the territorial sea. And one of the pictures, the one on the bottom right that you can see, is from what's known as the Whiskey on the Rocks incident, which is when a Whiskey-class submarine belonging to the Soviet Union, as it then was, had a bit of a navigational error when it was trying to spy on Swedish naval bases and got stranded on some rocks in the Swedish territorial sea. So one of the things with submarines is, since the earliest times, has been figuring out, well, what are the rules when submarines are coming through the territorial sea of a state? So obviously, once you're talking about military submarines, there are strategic advantages to having your submarines go submerged through these areas. Now, generally, the position of submarines is going to be conflated with warships, and mostly that's going to be sufficient in a number of instances. But looking back at the early history, and our other co-author, Kate Purcell, looked very closely into the legal history all around submarines. And there's definite lessons that we get from that early history that need to inform how we understand some of these rules today. And indeed, actually, I think informed some of the very contemporary debates we have, particularly around military uses of the oceans generally. And one of the things I think worth underlining here is that even when submarines were predominantly warships, they were predominantly being used by governments, there was early on recognition that there would be private uses because they were being used as blockade runners. So, of course, there was a possibility that there was going to be commercial uses for them. In the early regulation, it was a lot about the neutrality laws that were being put in place by different countries during World War I, particularly, and then subsequently with World War II as well. And in World War I, these early neutrality laws were the ones that first started saying, well, when we're dealing with submarines, we do expect submarines to surface and show their flag. And also there was a lot of discussion about the powers of a coastal state to be able to regulate. And really one of the most interesting things, I think, going back to this debate, and not specific to submarines, but certainly about warships, where we still to this day have debates between countries, particularly China and the United States, about whether warships can go through a territorial sea without seeking prior notice or prior authorization. Some of the early debates actually show that coastal states did have the power to insist upon that. But when you go through the drafting history, there was little change in the reporting that then got picked up in subsequent drafts. And I think the drafting history is actually quite telling in that respect. But let's leave the history and think about the contemporary rules. I'm happy to talk about the history some more if you're interested later on. But once we talk about contemporary rules for submarines going through the territorial sea, the first thing to notice is that we're talking about the ships of all states. So again, we're interested in whether something is a ship or not. So can a glider, can a spy shark have the right of innocent passage if they're not ships? And then we have to think about how it is that a submarine or any vessel is transiting through a territorial sea. So we have all the standards that have been set out in UNCLOS through the Corfu Channel case. But where we have particular interest for submarines is not so much Article 19, but Article 20. And in the end, I think it is one of the only, certainly within UNCLOS, it is the only rule that we have that explicitly mentions submarines in the entire convention. And I think it's probably the clearest rule of international law we have about submarines. So, you know, there's part of me going, oh, well, we have a 500-page book, and at the end of all of that, we've got one really, really clear rule about submarines. And that is that when they are traversing the territorial sea, they must surface and show their flag. So it also comes out when you go through the drafting history and you think about how Article 20 came to be, that it's fairly clear that if a submarine does not surface and show its flag, then not only is that a violation of Article 20, but also a violation of the right of innocent passage. And that matters because then what can you do in response? So Professor Krasker has thought about this issue and has a great article that goes through a lot of the state practice around the fact that many states send their submarines submerged into the territorial seas of other countries. And that includes the United States doing that. So Professor Krasker has argued that, in fact, there is a version of passage that would allow for submerged passage, arguing that the right of innocent passage is a privilege that can be accepted or rejected. And if it is rejected, then you still get a form of non-innocent passage, which is still lawful, but it's not a right and it's not protected. I think that if a state rejects the right or the privilege of innocent passage, then all that's left is the sovereignty of a coastal state, and you don't get to send your vehicles in for spying purposes. There's some interesting debates to be had about how spying is regulated under international law. The reality is that states do violate Article 20 in terms of sending their submarines in submerged. And so then the question is, well, what can you do? So remember the whiskey on the rocks. Well, following that particular incident, Sweden adopted legislation saying that what it would do was to drop low power depth charges. Because what you're supposed to do under Articles 25 and Article 30 of UNCLOS is you ask a warship to leave. But how do you ask a submerged submarine to leave? And particularly, you might be able to radio a submerged submarine. But if there's no crew on your submarine that is submerged in your territorial sea, then how do you communicate with it? So the low power depth charges is one way to communicate a message that you would like that submarine to surface or to leave your territorial sea. But at the moment that you start dropping these depth charges on something that is a warship, at what point do you then start violating your prohibition on the use of force, particularly when you are targeting a sovereign immune vessel that belongs to another state? So there are some questions about degree and about context that we then have to start thinking about. Anyway, we can come back to that in the question time. Let me move on to submarine activities in the exclusive economic zone. And here, a lot of the questions that come up for submarines, I think, are very much paralleled with the issues we have for warships generally. So I want to focus here again in terms of our newest submarines, in terms of autonomous vehicles and how that changes things. And particularly because we're dealing with gliders and floats and how they are being used. And I think it really does make the question about what counts as military research, which is not regulated by a coastal state, versus what is marine scientific research and is regulated by a coastal state. I think it brings that debate into a much sharper relief when we are thinking about these questions for autonomous vehicles. Interestingly, and back to crewed submarines for a moment, one of the examples that we talk about in the book in relation to research that is undertaken by submarines was a program that the US followed in the Arctic during the 1990s, when the US submarines invited scientists to come on board those submarines and to be able to collect data and use that research for examining all different aspects around the Arctic. But subsequently, the US shut down that particular program and then changed the way that it dealt with the scientists. But I think the way that it does it really shows the distinction that is drawn between military research and marine scientific research, where there is a distinct contrast in the way that the data being collected is being used and to what extent is being shared publicly that makes a difference. And I think that kind of distinction is still relevant for how we think about the type of data that's being collected by gliders and by floats. I can talk as much as anybody wants about that debate around military activities in the EEZ, but in relation to gliders and floats, one of the challenges I think we have is that because they are relatively small, they can be seized by other countries when they come across them. And so there is a question about, well, what sovereign immunity is enjoyed? And again, we come back to that debate, because are these ships or not? Because under UNCLOS, we know that ships, or warships particularly, enjoy complete immunity. But if something is not a warship, these little gliders that are lined up here, at least I like the fact in this photo they have little flags painted on the gliders so we know who they belong to. But if they're not a warship, do they enjoy complete immunity? We know from the Convention on Jurisdictional Immunities that military property enjoys immunity, but the problem is that treaty has not entered into force. So to what extent is that customary international law? At the moment, state practice is still mixed on states that protest the collection of gliders and those that don't, possibly because they want to deny the fact that they had gliders going into the territorial sea or exclusive economic zones of other states. So how autonomous vehicles are regulated within the EEZ, I think, is perpetuating a lot of the difficult questions we've had around military research versus marine scientific research, the permissibility of military activities or intelligence gathering, and has created a new issue in terms of the immunity that are enjoyed by these types of vehicles as well. The final issue I wanted to flag for today concerns private submarines, because, as I said, we mostly just think about these as warships, but it is important not to lose sight of the fact that private ownership happens in relation to these different craft. And again, we can sort of go, well, for some of these, it's relatively straightforward. Once you're talking about these remotely operated vehicles that are being, sent down to gather data, to repair submarine cables, well, they're going to be governed by the existing legal regime for seabed mining or for submarine cables, notwithstanding some of the deficits in those regimes. But I think where we've got a significant problem is more around the private uses for tourism, for leisure purposes, because when it comes to navigational safety and it comes to submarines, and certainly when it comes to the autonomous vehicles as well, there is a real lack of rules that apply. Even when we're talking about your traditional submarine, which does have crew on board, and we're thinking about the coal regs, which are the key treaty governing the rules of the road on the oceans. Those rules apply when the ships are all on the surface and you know who to give way to and what signals and sounds to have. But if something is under the water, then we don't actually have rules that deal with what happens when a submarine is surfacing. And when we started looking at the different submarine accidents, some of the main submarine accidents happen when a submarine is surfacing and it doesn't quite know what's above it. The other fun thing that happens, particularly with nuclear submarines, is because of the way they operate, which is to ensure that they are not detected or detectable, is that they don't necessarily know there are other nuclear submarines out there. And there was a collision between a French nuclear submarine and a British nuclear submarine. They were both out patrolling. They both went back to port and said, we hit something at some point. We don't know quite what. And it was only when the reports were compared that they realized they'd actually hit each other. So one would think that could be something we might like to have rules around and regulating. And I think even at a very preliminary level, we need some sort of guidelines, one would hope possible between allies at the very least, around the movement of submarines and how we can be aware of these. Once we're talking about the private submarines, and really came very strongly to light when the OceanGate submersible, the Titan, imploded. These small submersibles usually work on the basis of a certification process, and an insurance is the way to try and regulate those particular standards. But OceanGate, there was information up on its website said, well, we're so advanced in what we're doing, we're moving faster than the certification process allows, so we're not going to go through that particular process. So there might have been a reason to look into that further. There was some discussion at the time that the IMO would look into it, but I don't think it has advanced particularly far. But of course, the other big issue around private submarines, and particularly the autonomous vehicles, and just up here on the picture you can see on the right, these are some autonomous vehicles that were seized by Spanish police that were being used for the transport of drugs and guns and money. The question is, well, how do we regulate the criminal users of these submarines? And the US has been dealing with this for some time with the narco submarines that were developed out of Colombia initially. When we look at the different offences, the 2005 SUA Convention, the Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, that particular treaty does include submersibles within the definition of a vessel. So even when we're talking about the autonomous ones, we know they can potentially be covered as a vehicle or a vessel cause that is part of an offence. The 1988 Drugs Convention, on the other hand, only talks about vessels. So there we are again. Is it a ship? Is it a vessel? Where this issue is going to play out particularly will be in the national law of particular states. And certainly when the International Maritime Organization went through its regulatory scoping exercise on maritime autonomous surface ships, the legal committee said, you know what, we're not going to look at the SUA Convention because we think it is a matter of domestic law. I don't think the convention is entirely impervious to international developments, but certainly states are going to need to give close consideration as to whether they have jurisdiction to deal with someone who is the remote control operator of one of these particular vehicles. What kind of participatory offences are on the books that might enable prosecution? And then what do you do when a Coast Guard encounters one of these at sea? How do you communicate to get it to stop if you're conducting a hot pursuit? If you want to conduct the right of visit, how is that going to happen? Can you just jam the electronics to be able to gain access to the particular vehicle? And then, of course, and as we've seen in recent practice, no shortage of issues about the amount of force that can be used to counter drug trafficking offences. And perhaps at least one of the advantages with the potential increase in autonomous vehicles for the use of drug trafficking is at least there will not be people on board to lose their lives when law enforcement heats up. But certainly in terms of the law enforcement standards that we have under international law in terms of what is reasonable, what is proportionate, that equation is going to change when you're dealing with vehicles that do not have people on board, and the likely scenario is that these things will just get sunk into the ocean. We can have separate conversations about the marine environmental consequences of that as well. So anyway, I have given you a bit of a helicopter view over some of the legal issues that arise in relation to submarines, as well as the newest form. And I will leave it there, but I'm happy to follow up with any questions and look into anything more closely. But thank you for your attention.